Hello and welcome to Quadcast, Quadrant Chamber's weekly discussion forum looking at legal developments, news and hot topics in the world of commercial litigation. The format is very simple. Drink, talk, chat. Drink, we want you all to join us for a drink. I am drinking a healthy Coca-Cola, but with a twist of lime, just to add a little bit of interest. And talk, we're going to talk about some legal topics, questions. Hopefully those are the registered have got their packs at the ready. We've got some case studies this week. And chat, we want you to join in by sending us comments, questions, observations as we go through. So joining me, Poonam Melwani, Claudia Wilmot-Smith and Joe Sullivan. Let's just go round and do some catch up. Claudia, what have you been up to this week?
Yes, hi, thanks, Paul. I am drinking peppermint tea, which is delicious. This week, I think I told you guys last week, I'm doing this Yale Introduction to Psychology course, and I've been learning about memory. This week, I've been learning a lot about false memory, in particular in witness testimony, which has actually been very interesting for someone who relies quite a lot on witness testimony, and got an assignment to devise how to implant false memory in someone, which I thought was quite interesting. So I have been thinking about ways to make people think that things happened when they did not in fact happen. How about you, Paul?
Well, this week I've been wondering about whether I should get a facelift, because what I've realised looking at camera with all these Zoom meetings that if you pull back your face just slightly like this, you lose about 5 years. So I've spent a bit of time thinking about, don't want to do anything too drastic or look like Frankenstein's monster or anything, but wondering about that. Joe, I mean, you've had several facelifts, haven't you? I think. What have you been up to this week?
Yeah, I'm not allowed to have any more cosmetic surgery. So I should say I'm supporting British industry. I'm drinking some Camden beer. I've had a pretty busy week with work, but apart from that, I've been trying to work through Chopin's waltzes with pretty mixed success, I've got to say. How about you, Poonam? Have you persuaded any of your family to help you with the domestic chores?
Well, as you know, I'm very grateful to Quadcast. The boys tuned into the first 5 minutes of last week's episode. They declared it got too legal and boring after that. But they heard me whinging about being a domestic goddess, didn't like being put down in that way on air. And they did a rota whereby now 5 men have cooked every night since the last podcast. And I've been taking it easy and sipping wine. So thank you to Quadcast.
On a rota.
It was very sweet.
Poonam, what do your family think about your appearance on the broadcast today?
Yeah, okay, we really shouldn't talk in advance. So about 5 minutes ago, everyone, I went down to pour myself my glass of wine and my 20-year-old said, "Is that what you're wearing for today's podcast?" Brave choice. And I was like, "Why? What's wrong?" And they were like, "Just so easy to wind up, Mummy." Anyway, enough.
Okay, well, look, thank you, everybody who sent in comments from last week. The feedback has been great. Let me just read out a few, give a few name checks. Kate from Fox Williams, a quick note to say how much I enjoyed Quadcast, both in format and content. I've had time in the past couple of weeks to attend a lot of webinars, but I really enjoyed this format. So refreshing to see the law being discussed in informal, friendly and engaging way. Jonathan from McFarland's, thought that was great. Pass on my thanks, congratulations to the team. And Ed from TLT, really enjoyed it. Thanks to all involved. Think you got the format length just right. It was an interesting subject. It's a high bar. I'm sure we'll fall short of it this week. Some other comments, I think, Claudia, you've got.
Yes, thanks for the positive comments. They're great. We've also had people saying that it's a bit wrong to ask everyone to join in our chat and ask questions if we don't make it clear how to do so. There are, in fact, 2 ways if anyone wants to ask any questions or put in any comments. The first is via YouTube itself. If you are logged in, it should give you an option to comment at the bottom. Click on Add Public Comment, and that will come up live on YouTube, and we will be able to see, we will get your comment. The second, for those who are probably the people who commented and who are like me and didn't realise that you log into YouTube, you can email us. We've set up an email address, quadcast@quadrantchambers.com. And if you email, our producer, Emily, will pick up all of your comments and questions and filter them through to us. So that's made it hopefully easier for you guys to join in. So thanks for that comment. And I think some of the people who wrote asking about how to ask questions actually did have questions. Paul or Poonam, perhaps. Joe or Poonam, I think, got some.
We had a question people remember from last week, about the Giles and Rind exception to the reflective loss principle. Someone asked whether and when it's ever actually been applied. And until this year, the only case that I'm aware of where the exception was applied was a case about 15 years ago called Perry and Day. And it was applied in that case where the company's claim was settled as part of the very transaction that was being impugned as part of the wrongdoing. But Poonam, you were saying that there'd been a more recent case this year.
Yeah, actually, since the Court of Appeal in Marix, there was a decision this year in 2020, strikeout saying you couldn't bring the proceedings. Mulder J held that the Giles and Rind exception was satisfied. She acknowledged it was a very high test of legal impossibility and very trammelled following the Court of Appeal. But there, the wrongdoer had made the company so impecunious that it hadn't been able to pay its company dues to stay on the register, had been struck off the register, so it couldn't bring an action. And Mulder was satisfied that she couldn't be sure it could be put back on. So she's allowed the case to go through on legal impossibility. Can I just say before we start doing this, there are other ways of getting comments, including by WhatsApp from members of Chambers. And I just had one saying, "You're shouting again, be quiet." So I'll try and keep my volume down. Over to you, Paul.
Okay, so this week we're going to look at COVID and some of the legal issues that people are talking about that have come up. We're going to do it in 4 case studies that if you registered for the program, you'll have copies of those emailed out. And we're going to take it in turns, go round. As I say, you can send your questions by the YouTube chat function or by emailing quadcast@quadrantchambers.com. And so I think, Claudio, you've got the first case study for us.
Sure, yeah, thanks. So there should be a slide that says what the question is. Thanks for that. This is a contract for the sale of masks to a plastic surgery clinic to fulfill Paul's every facelift desire. Delivery in London. The seller is Chinese. They have been shipping masks from their factory in China, but they can't anymore because their factory has been requisitioned. They tell the buyer they won't deliver. Can the buyer claim damages? Answers. Joe?
Yes, I think they can.
Poonam?
Sorry to be boring, but I agree with Joe, yes.
I'm keeping score here. I won't tell you how I'm grading until I hear Paul's answer.
Well, I know I'm going to be in the minority here, and I know that I'm going out on a limb, but I'm going to say they cannot claim damages. I say that the contract's been frustrated.
Okay, so that is 1 point to Poonam and Joe, and our esteemed leader fails.
No.
Contract is for sale, so the test for frustration is usually about impossibility or extreme impracticability of performance. This is a contract that requires delivery in London. I think I probably therefore know what Paul's answer would be to the next question, which is, would your answer be different if the contract was to manufacture in China and sell in London? The first question, the reason why I say Poonam and Joe are right is because there's nothing stopping them delivering in London. They could source the mask from elsewhere. But here, would you guys give the same answer? Poonam,
I
Joe?
wouldn't. I think in that case it probably is frustrated.
And Poonam?
I would give the same answer, and I certainly don't accept that the contract is frustrated.
Paul, are you sticking by your original answer?
Yeah, and I don't accept the whole thing about buying them in from elsewhere, because I say that this is a specific contract for these masks from this manufacturer. Masks are all different. And so I don't accept your answer, but there you are.
Are you writing your own contract there, Paul?
So masks generally have a specification, but as long as you can get masks of the same specification, I don't think they've been apportioned to the contract. I would give Poonam a point for saying that the contract hasn't been frustrated. This was a long-term supply contract, so you supply every month over a 2-year period. And there is the fact that they may not be able to perform the March shipment doesn't mean that the entire contract is frustrated. But I would give Joe a point for saying that the buyer, that the answer is different, because I think in this case, under the common law, when you can separate a contract and sever various obligations, then you can discharge part of it. So I would say the March shipment has been discharged by the impossibility of performance, the illegality in China. but the rest of the contract remains afoot, and the parties assume the rest of their obligations. So April onwards, assuming the situation has changed. Paul, why you agree with Joe that it was frustrated?
I think that the essence for frustration is there, because I think that there are three basic points. Firstly, you've got to pass the sniff test as to whether the event is sufficiently catastrophic. And I think coronavirus is an absolute prime example of frustration. You compare it with the coronation cases or the Suez cases, and it's far more serious than that. There seems to be genuine impossibility here because the factory is requisitioned, and it's a bit like those ship cases where the vessel is requisitioned. We've got no information that the masts are interchangeable from elsewhere, genuine impossibility, and no evidence that it's been priced into the deal. So I stay by my frustrated, yeah.
Claudia, we've had a question from the audience saying, does it make any difference to this debate if there's been a force majeure certificate issued by the Chinese government? And we know that since February, the government has been issuing FM certificates. I have a view on that in the context of your problem, but it's your problem, sweetheart. So what's your answer to the question from the audience?
So this is a question in which there's no force majeure provision in the contract, but I have said that I would accept that if the March shipment is incapable of performance, then the seller would be discharged from responsibility, and the force majeure certificate would be something that they could adduce to say, I cannot perform this shipment. I don't agree with Paul that would mean the entire contract is frustrated. It's got another year or so to run, and this was a fairly short-lived ban. Shipments started again mid-March. But I'm going to ask, would your answers be different if it turned out the factory hadn't been requisitioned by the government? It was illegal, in fact, to ship the masks, but in practice it was possible because the market for masks is booming, and so you have unscrupulous black market traders shipping out of China. In that case, it might be unlawful, but they can perform. Would you say that the sellers are obliged to perform? And if they don't, can the buyers claim damages?
I don't think they'd be obliged to perform, but they would have a different defence. I think they'd have an illegality defence rather than an impossibility defence.
Yeah, I agree with Joe. I agree that because the beauty of illegality is it can have a suspensory effect. So you can suspend the operation of the contract for the period of the illegality. So I go with that. Yeah, I agree with Joe.
Pooran?
Sorry to be boring, but yes, I agree. The court's not going to award damages, which would require, in this circumstance, saying that the seller, the supplier, has to ship in a way that's illegal according to the place of performance.
Okay, but imagine the buyer finds out that the seller prepared the mask for shipment. They were on the runway in China, and a bunch of Americans swooped in with a suitcase full of cash, which has apparently been happening. It sounds like the Wild West out there. Said, we'll pay you $100 a mask, and they got the shipment. So the buyer sues, the seller says it was illegal for me to ship them, but the buyer says, well, you could have and did ship them because the Americans got them. Would that change your answer?
No.
No.
Because the illegality
It should?
The illegality is an objective fact, isn't it? Once you've established illegality, it would be very odd if then you can make it unillegal simply by acting illegally yourself.
I agree with that. We're obviously all very high, upstanding citizens here, but yeah, I can't see the court sanctioning that you get damages by insisting the other side does an illegal performance, which is what that would involve. Joe, we're moving on to your problem now. Are you next?
Sure, yeah. So
we haven't discussed the Achilles.
That's because
that is a whole can of worms.
I had something to say about that.
Achilles, go on, Claudia.
The Achilles is a can of worms. So the reason I put this in, partly because I think it's very interesting because it's a can of worms, but also Paul said that we're keeping score and the question master gets to determine who gets what points for what question. So I'm going to make you all answer so I can decide whose answer I like, but keep it to one sentence each. Go.
I think the Achilles would apply in your scenario.
What does that mean? As in, they can limit recoverable damages?
Yes.
Okay. Does anyone agree with Joe?
No.
No. Okay, you wanted a one-line answer. I don't agree. I think the claim for difference between market value and contract value is, even on the majority, a type of loss that was assumed responsibility for. And I don't buy the minority view that market volatility is enough. I think the markets are volatile. That's why you have market prices as a moving function. So no, I disagree with Joe.
And the ratio of Achilles has nothing to do with market volatility. If you read it, it has to do with the fact that the follow-on charter is not within the Hadlin-Baxendale first head. So that's my answer.
Okay, I'm going to give you a point for being straightforward. Poonam a point because I like to have explanation, and I'm going to take a point off Paul because he's making the Achillea sound like it's too obvious. The ratio is obviously this. I said this question so I could be propitious. Joe, your questions. I'm going to send my scores to Emily so we can keep score.
Great. So could we have my first slide, please? So my question concerns a contract that has an arbitration clause in the form that's up on the slide. It's a named arbitrator with a time limit for starting and completing the arbitration of 3 months. And the arbitrator can be replaced by the court, but only in the event of his death, incapacity, or refusal to act. The situation is you've got a breach of contract on the 1st of January. Arbitration starts in time on the 1st of March. Hearing is scheduled just over 2 months later, but the arbitrator, Mr. Rumpole, is taken down with COVID-19 abroad. He's in hospital. He can work, but he's got connection problems. The question for you first, Poonam, is what should the parties do?
The parties should apply to the court to appoint an alternative arbitrator. In my view, particularly given the entire thing, 3 months to finish, etc., Mr. Rumpole has an incapacity to act. I know he's physically well enough, but he is incapable of acting in light of the restrictions on his phone calls and videos. So make an application to court in that way. I have subsidiary answers, but I'll let someone else say that. That's my first position. Well, Paul, you're going to disagree with me again?
Well, I can see that. I mean, the straightforward answer is if the parties can agree on an alternative arbitrator, then problem solved. So, but if the parties can't agree, and one of them is going to be difficult, I'm not convinced it is a case of incapacity. I think that this is one of those situations where the machinery is broken down and you can rely on Subbrook and Eggleton, and the court can then step in and resolve the dispute. And one thing that did trouble me about that was whether you could use Subbrook in an arbitration case or whether it would be argued that the 96 Act, you're nodding, Poonam, but unfortunately for you, Riverpath and Bramall is a first instance decision of Miss Justice Neuberger, and he did apply Subbrook and Eggleton in circumstances where there's an arbitration agreement. So I think you can apply that case.
And what do you think, Claudia?
There is, I would say that there's actually dicta about whether or not the death of an arbitrator fits into that rule that Paul said. The question is what the parties should do. I agree with Poonam. They could apply to court. I think they should try to agree an alternative appointment. I also think that given the 3 month type time limit, they should try to agree that the proceedings and every step taken in the proceedings so far stand, because I think there's a risk that once the new arbitrator is appointed, they'd have to start again. And I think they should try to agree, consistent with their duty of cooperation, to do everything to happen quickly, that every step taken so far is valid and remains good for the arbitration commenced with the new arbitrator.
Poonam, would your answer be different if you just assume for the time being that the arbitrator is not incapable or does not lack capacity as a matter of construction of the clause?
Yeah, if you decided it wasn't incapable, so where the parties have agreed an alternative could be appointed. I thought about whether you'd apply under Section 18, where there's been a failure in the appointment of an arbitrator. But there has not been a failing in the appointment, and there have been some cases that have taken a very narrow proposition of that, then I think actually it'd be very different. Then I'd say what they agreed to was Horace. Horace can't do it. I wouldn't allow for the court to appoint a substitute arbitrator. I'd then say the arbitration agreement is incapable of being performed and is therefore gone. And you're now without an arbitration clause, without the time restrictions, but you just have to find the proper law and proper jurisdiction as if you didn't have the arbitration clause. I don't think you can go through the back door of Section 18 to get what the front door that they've provided for in the clause doesn't allow for. And of course, back door of Paul's case either. Both of them are back doors.
And of course, Section 18 is one of the non-mandatory elements of the Arbitration Act, isn't it? And so couldn't it be said that by the language they've used in this arbitration clause, they've excluded the application of Section 18?
You asking me again, or are you putting someone else in the hot spot?
Why don't I ask Paul? Go on, Paul.
Well, Section 18 I don't think applies. I see the force of that, but Section 18 doesn't apply because I looked at Section 18 quite carefully, and it is directed at a failure in appointment. And I can't get from this case study any suggestion there's been a failure in the appointment. The appointment was successful. So I agree with Poonam on that.
Claudia, what do you think about Section 24 of the Arbitration Act, which is a mandatory provision, about the court removing the arbitrator because of his incapacity? Would that be a way?
Well, the agreement provides for what can happen in the event of incapacity. You said this issue arises if he's not incapacitated. So in that circumstance, I'm not sure why you would fall back on Section 24 if it's found as a fact there's no incapacity. I agree with Poonam. I don't think he has capacity to conduct an arbitration, and so I think that you should go to court.
You'll be pleased to know we've had a comment saying we love your cat in the background.
I'm like trying to get him out the way.
It's all right.
Sorry, I didn't close my door and my cat's coming.
It's fine.
Well,
Joe, I'm very competitive. Can you award points, please?
Everyone has pretty much the right idea about applying to court, although different ways about it. So I'm giving everyone 3 points for my question. And I think, Paul, are you up next?
Yeah, I'm next. Okay, so I've got a banking question. This is based on a real situation that I had crop up just about a week ago. So we have a standby letter of credit issued by a bank, Barwest, fictitious bank, demand to be made on a business day. Yesterday, so Wednesday, in the City of London, in the square mile around the Bank of England, less than a third of all branches are open, and those that are open are only open 10 till 2. Banks maintain online services and telephone support. The question is, was yesterday a business day in London? Poonam?
No, it was not a business day. Am I allowed a one-line answer, or are you just going around for answers?
We'll go around for answers because then I'm going to give you a few more sort of things to think about. Joe, what do you say?
Yes, it was a business day.
And Claudia?
I also say it was.
Okay, and all right, Poonam, yours is the most interesting answer. Why not a business day?
Okay, so I don't give two hoots about online banking services and phone support being open, because the definition is when banks are generally open for business in the place where presentation is located. For me, that's a physical location. Generally open, I'm not saying it's more than 50%, but to me, it's not generally open when it's a third of banks, and that too for about half the normal business working day length. So that's the reasons for my answer.
I mean, the facts were, I got this all from Google Maps. So there are 4 Barclays branches close within distance of Bank Tube. I took Bank Tube being the centre. They were all closed. There was one NatWest branch that was open out of 4. HSBC, 3 out of 4 were closed. 1 was open in Queen Victoria Street, and Lloyd's 3 out of 4 open. I mean, Joe, you say it is a business day. I mean, on what basis when you've got that number of branches shut?
Because I would construe it as being about the generality of the day and not about the majority, whether a majority of banks are in fact open on that particular day. It's about whether generally on that sort of a day, so on a midweek day that's not a bank holiday or a holiday of another type, that is a day that banks are generally open.
So, I mean, this is a very common clause, as probably everybody's aware. We find this clause, it was in the standby letter of credit I was looking at. It's in UCP Article 2. It's in the ISDA Master Agreement. It's in the JC2 construction contracts. Very common clause. I think that a judge will lean to find that it was a business day. But let me just ask this follow-up question, because this is a real potential problem. So assume that Barwest only has one office and the standby expires tomorrow and you've got to make the demand tomorrow, but your information is that the doors to Barwest are shut. What do you do? I've got four choices. Do you send demand by email, demand by fax, post it through the letterbox, or post by first class post? Joe, what do you say?
Email.
Claudia?
I would probably do all of them.
And Poonam?
Cover all bases.
Being pernickety, I'm not sure you told me what the service requirement is, but I would go for the only two I'd go for email and through the letterbox, even though there's no one in the office.
Yeah, I mean, my view is you do all of them, not post through the post, but certainly the letterbox. And you probably do it with a lawyer ready to swear an affidavit at the point. I mean, the fallback is always physical presentation of documents under a letter of credit. But anyway, okay, so that's my problem. Oh, you want some marks, don't you? I'm going to give Poonam, I'm going to give you all 1 mark, I think, for that, because I think that Poonam got the second part right. To be honest with you, I wasn't paying enough attention. I'm going to give you all 1 mark, just like Joe. I'm going to be nice to everybody.
I gave 3 marks.
Yeah, I know, but you weren't that good.
Okay, Joe, can I say I'll give you a bonus mark because your answer actually gave me pause for thought and made me think in a different way. So I think that's an excellent answer. Right, on to mine. And if we were to stick into 30 minutes, I'd have 4 minutes left. So we might be overrunning by 5 or 6 minutes in this quadcast so that I get my little moment with my question. If we get the slide up about ARBCO, the Arbitration Centre in London, it's got a 5-day arbitration due to start. Got T&Cs where it will be liable. It's also going to suffer its own loss if it cancels. They're worried about COVID-19. They decide to cancel the arbitration on the 3rd of March. Policy covers financial loss, and you need to read the words of the clause because the clause is king. Financial loss arising from an interruption to the business caused by an occurrence of a notifiable human disease. 3rd of March when they cancelled, it wasn't a notifiable disease in England, became notifiable on 5th of March. On to the next slide, the question. First one, insurers say not liable for legal liability or loss because the arbitration was cancelled before the 5th. And the other side, the assured says it was commenced after the 5th, so that's a bad defence. Can we deal with that one first? Claudia, who's right? Insurers or assured? Is it covered?
No, I think you look at whether it was a notifiable disease on the day in question and whether it was notifiable disease in the relevant jurisdiction. Here it wasn't.
Okay,
so,
cool.
Yeah, I agree with that. I think the key point in time is the point at which the loss is incurred. And that,
which you would say is when?
Is when they cancel.
Okay, Joe, you're going to make this interesting with a different answer, or are you agreeing with the pack?
I'm going to disagree, and I'm going to say that ARBCO is right because the cancellation was in fact caused by a disease that was notifiable. It's just that they didn't know it was notifiable when they cancelled.
Well, you could have been counsel arguing the case in the Court of Final Appeal in Hong Kong when it arose in 2012 in the context of the SARS epidemic. But like the counsel in Hong Kong, you would have gone down in flames, where the court held that the reasoning Paul and Claudia gave was entirely correct. And I would just throw this out by comment, and Joe, tell me whether you agree. I mean, that promotes commercial certainty. You can't have things being retrospective. Part of the idea is that when a loss is incurred, you need to know at that point whether the insured peril exists or doesn't exist. You don't look for future events. Would you accept that commercial certainty makes Paul and Claudia more correct than you?
Reluctantly, yes, I would.
You're being nice just because I was nice to you earlier. Okay. All right. Right. The next question, there is no exact case on, and it's really a question that's troubling everyone in the context of insurance, force majeure, and everything else. Now let's fast forward and assume they've cancelled after notifiable disease. So that argument's gone. We might need the first slide again, please, which actually has the clause. So they cancel after the government lockdown, when there's a government lockdown, but the insurers say, no, it's not COVID-19 that caused the loss. It's the government reaction to COVID-19. It's fears about COVID-19. So the question is, and I'll go to Paul first, are insurers correct?
No, I think
so that they state liability. Go on.
Sorry, I think that they're wrong, because I think that the causation, it's too strained an argument. The proximate cause of the cancellation is COVID-19. And I would use the sort of mitigation of damage type analysis to say that if you reasonably act in a situation to reduce or avoid loss, then that's claimable. So, yeah, I think they're wrong.
Okay, I'm not sure I follow your mitigation, but we'll come back to that. Claudia?
I would also say that the proximate cause was COVID-19. I think whilst you could argue that the immediate cause was government regulations, the proximate cause of those regulations was COVID-19. That's what required the government to impose the lockdown. And otherwise, I think you might find yourself in a situation where the worse the disease, the less likely something is to be covered, but because it's more likely that there would be a government or something taking further action. So I think it's more like the case where you don't look at the very final thing in time, you look at the
originating
proximate cause.
Joe?
I'm afraid tediously I'm going to have to agree with Paul and Claudia.
Oh, not tedious at all, because you're the first person to give me the right answer in my view. I mean, a lot of people watching will be thrilled by Paul and Claudia's answer, because this is the question. In force majeure, in insurance, in reinsurance, is the disease the cause, or is the government lockdown's response the cause? And that's going to be litigated in a million different cases, all also depending on the clause in question. For example, mine was arising from financial loss arising from a notifiable disease. If it was financial loss in connection with, then it's even easier to make Paul's position. There are 2 bonus points on offer here, and neither of you have spotted the little wrinkles. The clause said that I quoted, and it's a reflection of some of the clauses in the market, financial loss caused by an occurrence of a notifiable disease. Does the word occurrence change anybody's answer?
No.
I'm not sure I would read that occurrence in the sort of classic insurance occurrence of an event type thing. I would say that the occurrence of the disease has caused everything that arises. And the reason I say in this case it's the disease, not the lockdown as well, is because it's not entirely clear it would be against the law to perform the arbitration agreement, because you're still allowed to work, for example.
Oh my God, you lose on the first bonus point, but you might get the second. For me, the occurrence makes it clearer that it's an occurrence of the disease. But the other bonus point was, and we're running out of time, so I'll do this, is of course even the government lockdown, whatever else it said, the legal system is essential services, and arbitration centres are allowed to carry on, unlike shops, pubs and restaurants. So even the government lockdown could be argued not to have been the cause of any loss, because arbitration centres are arguably exempt. Right, so who am I awarding a point to? 2 to Joe for getting the important question right. You all got, 2 to Joe, 1 to Paul, 1 to Claudia, but 1 for the bonus. So 2-2-1. Emily, keep the scores. 2-2-1. Right, okay, where do we go next, Paul?
Well, we've got a couple of questions in. So Stephen Taylor Heath who's at JMW Solicitors, asked regarding Claudia, your question, if illegality has suspensory effect, does that mean only acts that fall foul of the COVID-19 Act have a suspensory effect as opposed to acts which would fall foul of government guidelines?
So I think it was Paul who said that illegality has a suspensory effect. I'm not sure I understand what that means.
For example, if it's illegal to repay a debt, and then the illegality is lifted for whatever reason, then the obligation to repay is reinstated.
Okay, so we're back to the
so you're saying it hasn't frustrated the contract. Well, that's if the contract has been frustrated because of something being illegal, then parties are discharged from further performance. In your example, the obligation to pay the debt accrued before the contract was frustrated or the illegality. So I would say that they're continued under that obligation. They may be relieved from performance to a certain extent during a period of illegality.
Okay. Well, let me ask another question. Joe, Tim Norman, partner at Meyerson, says this, or perhaps to all of you actually, cannot one of the parties ask Mr. Rumpole to refuse to act?
Yes, and that would probably, I mean, you would still have the same potential issues about the initial bargain if it was just one party doing it, but it would help under any application under Section 24 of the Arbitration Act if he would do that.
Okay, and on my question, Janine Alexander has asked on YouTube, is there a distinction depending on the extent of the services banks in general offer online or by phone? I mean, nobody picked up on that point, but in my view, you go for the traditional view, which is that the bank is open when unless it says otherwise, it is open for its normal business, which is retail banking, collection of checks. If you look at Joe Atkinson, the conventional business of the banker is running accounts for people. So I don't think online matters, but I could see it be argued the other way. Okay, so the scores on the doors, everybody. So Poonam got 4, Joe got 5. I've got an ambiguous, it says I've got 4 and then 5 maybe. But anyway, Claudia wins with 6 points. So well done, Claudia.
Well done, Claudia.
Thanks, guys.
Excellent. Okay,
and
so
everyone to watch, yeah.
That leaves it just to me to say thank you very much to Emily Saunderson, who's been managing us and producing this behind the scenes, and also to Fisheye Productions, Ben Jacobs, who's been doing the live streaming and the vision mixing and the like. Next week, we are going to look at the 2 vicarious liability decisions that were delivered on the same day earlier this month, the Morrison's case and the Barclays case, and look at the state of the law on vicarious liability and what that means. And we're going to be doing it live, jumping out of an aeroplane. No, we're not. We're not going to be doing that. We're just going to discuss the issues. So join us next week, Thursday, 5 p.m. Quadcast. Thank you very much for watching.
Thank you.